In the sweltering Philadelphia summer of 1787, a gathering of America's most prominent minds embarked on a monumental task. The fledgling nation, born from revolution and bound by the flimsy Articles of Confederation, was teetering on the brink of collapse. The existing government was too weak to manage debts, defend its borders, regulate commerce between the states. The delegates did not merely seek to revise the old rules, they aimed to create an entirely new framework for governance. Their audacious goal was to construct a durable republic, a government of the people that could balance liberty with order and unite 13 disparate states into a single, cohesive nation. It was an act of creation, a bold attempt to forge a government that would endure for ages. The document that emerged from this convention, the United States Constitution, was a marvel of political engineering. It began with a powerful and revolutionary declaration, "We the people of the United States." This simple phrase signaled a profound shift in the philosophy of governance. Power did not flow from a monarch or from the states themselves, but directly from the sovereign citizenry of the entire nation. It then laid out the ambitious purposes of this new government: to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, secure the blessings of liberty to ourselves and our posterity. They were the guiding principles, the very soul of the constitutional project that would follow. Following this eloquent introduction, the Constitution is methodically organized into 7 distinct articles. Article 1 establishes the legislative branch. Article 2, the executive. Article 3, the judiciary. Article 4 addresses the relationships between the states. Article 5 sets the process for amending the document. Article 6 declares the supremacy of federal law. Article 7 lays out the requirements for ratification. This deliberate structure was not accidental. It was designed to provide clarity, to delineate powers carefully, and to create a logical blueprint that future generations could read, understand, and apply. The founders were building not just for their time, but for an unknown future. The creation of this blueprint was anything but simple. The delegates represented a wide array of interests. Large, populous states like Virginia, small, vulnerable ones like Delaware. They disagreed on fundamental questions about representation, power, the very nature of the republic. The resulting document was, therefore, a tapestry of compromises, a negotiated settlement between competing visions. It was a practical document forged in the crucible of debate, designed to solve the immediate problems facing the nation, while also establishing a lasting foundation. The framers understood that their creation was imperfect, but they believed it was the best possible plan to secure the future of the United States and prevent the descent into anarchy or tyranny that had befallen so many republics before it. The structure of the legislative branch itself was one of the most contentious issues at the Constitutional Convention. Delegates from large states like Virginia advocated for a system of proportional representation where a state's number of lawmakers would be based on its population. This, they argued, was the only truly democratic approach. Conversely, delegates from smaller states feared that such a system would render them powerless, New Jersey, Delaware. They pushed for equal representation, where each state would have the same number of votes regardless of its size. This fundamental disagreement led to a deadlock that nearly ended the convention. The solution came in the form of the Connecticut Compromise, often called the Great Compromise. This proposal created a bicameral legislature, a Congress with 2 separate chambers. The first chamber, the House of Representatives, would satisfy the large states by basing representation on population. States with more people would have more representatives, making it the chamber most closely tied to the popular will. Members of the House would be elected directly by the people. This chamber was designed to be the energetic and immediate reflection of the public mood, where popular passions could find expression. The second chamber, the Senate, was designed to appease the small states and act as a moderating force. In the Senate, every state, no matter how large or small, would have exactly 2 senators. This ensured that states like Rhode Island, Delaware would have the same voting power in the Senate as giants like Virginia, Pennsylvania. Originally, senators were not elected directly by the people, but were chosen by the state legislatures. a method intended to insulate them from the fleeting whims of mass opinion. With longer, staggered 6-year terms, senators were expected to take a more long-term, deliberative view, acting as a saucer to cool the hot tea passed by the House. This two-house structure was more than just a political fix. It was a core element of the system of checks and balances within the legislative branch itself. For a bill to become a law, and by the Senate, this requirement forces two different kinds of majorities to agree: a majority of the people as represented in the House, a majority of the states as represented in the Senate. This dual consent mechanism was intended to produce more carefully considered and broadly acceptable legislation. It prevented the tyranny of a simple majority and ensured that the interests of the nation as a whole were protected, and that the interests of the individual states were protected. The debate was intense, balancing fear of tyranny against the need for an energetic, responsible leader. Ultimately, proponents of a single executive won. Article 2 established the office of the President, vesting in one person the federal government's executive power. The President was made Commander-in-Chief of the Army and Navy, given the power to grant pardons, and tasked with ensuring laws are faithfully executed. To check this power, framers gave the president a fixed 4-year term and made the office subject to impeachment by Congress. They also gave the Senate the power to approve treaties and to confirm presidential appointments, so the executive could not act alone. Creating a single accountable president was a gamble. Selecting that figure sparked deep disagreement. Many delegates distrusted direct popular election and would pick a favorite son from their state. They worried direct election could lead to chaos and mob rule. Electing the president by Congress was rejected as making the office subservient to the legislature. Delegates needed a novel balance between democratic principles and checks on popular passion and legislative dominance. The solution was the Electoral College. Under it, the president is not chosen by a national popular vote. Instead, each state gets electors equal to its number of senators and its number of representatives in Congress. On election day, voters pick a slate of those electors, each pledged to a presidential candidate. The electors then meet in their states to cast the official votes for president. The Electoral College was a compromise, a filter between the people and the presidency, meant to ensure broad cross-regional support and some measure of deliberation. While the preamble grandly declared "we the people" as the source of authority, the question of who, exactly, constituted the people with the power to vote was left largely unanswered by the original Constitution. The document itself is nearly silent on voting qualifications. Instead of establishing a uniform national standard for suffrage, Article 1, Section 2 simply states for elections to the House of Representatives, voters shall have the qualifications requisite for electors of the most numerous branch of the state legislature. In essence, the framers punted the decision to the states. Anyone eligible to vote for their state representatives could also vote for members of the U.S. Congress. This created a diverse and highly restrictive patchwork of voting laws across the young nation. In 1787, the franchise was overwhelmingly limited to a small, privileged segment of the population. The most common requirement was property ownership. Many states believed only men who owned land or significant personal property had the independence to vote responsibly. This excluded a large portion of adult men from the political process. Tenant farmers, laborers, apprentices, artisans. The ideal voter was an economically independent white male head of household. The exclusion of vast segments of the population was stark and absolute. Women, regardless of their property or social standing, were universally denied the right to vote. The era's patriarchal ideology saw women as dependents lacking independent judgment. Similarly, enslaved African Americans were considered property and barred from civic life. Even free African Americans faced severe restrictions and were, in most states, denied the franchise. Indigenous peoples were also generally excluded, seen as members of separate sovereign nations. Consequently, the democratic promise of the early republic was profoundly limited. The electorate was likely only 10 to 15% of the population. The Constitution established a revolutionary government in theory, but in practice, it was an elite republic for propertied white men. The expansion of suffrage to include Poor men, women, people of color would become one of the longest and most arduous struggles in American history. The institution of slavery cast a long and dark shadow over the proceedings in Philadelphia. It was the great, unspoken contradiction at the heart of a nation founded on the principle of liberty. The delegates knew that forging a union between the slaveholding southern states and the increasingly abolitionist northern states would require painful compromises. While the words slave, slavery were deliberately omitted from the text, their influence is woven into the very fabric of the original Constitution through three key provisions. These compromises were the price of unity, a devil's bargain that embedded the institution of human bondage into the nation's founding law, setting the stage for future conflict. The first and most notorious of these was the 3/5 Compromise. The question of how to count the enslaved population was critical for determining both a state's representation in the House of Representatives and its share of federal taxes. Southern delegates insisted that enslaved people should be counted fully for representation, but not for taxation. Northern delegates argued the opposite. The resulting compromise, laid out in Article 1, Section 2, stipulated that for both purposes, the enslaved population would be counted as 3/5 of their actual number. This formula artificially inflated the political power of the slave states in Congress and the Electoral College for decades to come. The second major compromise concerned the international slave trade. Many Northern delegates wished to abolish the horrific transatlantic trade in human beings immediately. However, states like South Carolina and Georgia, whose economies were heavily dependent on a continuous supply of enslaved labor, threatened to walk out of the convention if the trade was banned. The compromise, found in Article 1, Section 9, prohibited Congress from outlawing the importation of slaves for a period of 20 years, until 1808. This clause effectively gave the slave states a 2-decade grace period to continue importing people as property, further entrenching the institution in the Deep South. It was a temporary reprieve that allowed the brutal trade to flourish. The third provision, known as the Fugitive Slave Clause, is located in Article 4, Section 2. This clause mandated that an enslaved person who escaped to a free state was not discharged from servitude, but must be delivered up on claim of the party to whom such service or labor may be due. This provision nationalized the institution of slavery by obligating free states to participate in its enforcement. It denied the principle that a person could become free by reaching free soil and instead required northern states to act as slave catchers for the South. Together, these three compromises demonstrated the immense power of the slaveholding interests at the convention and the high moral cost of creating the more perfect union. When the Constitution was presented to the states for ratification, one of the most immediate and powerful criticisms was its shocking lack of a Bill of Rights. The 1787 document meticulously structured the government and defined its powers, but it failed to explicitly protect the fundamental liberties of the individual citizen against potential government overreach. For many Americans fresh from revolution, this omission was a glaring and dangerous flaw. They demanded a clear enumeration of the people's most basic freedoms. The list of unprotected rights was long and alarming. Freedom of speech, freedom of the press, freedom of religion, trial by jury in most civil cases, protection against unreasonable searches and seizures, the right to not be forced to testify against oneself. The proponents of the Constitution, the Federalists, argued that a Bill of Rights was unnecessary and even dangerous. They contended that the new government was one of limited enumerated powers. Since it had not been given the power to regulate speech or religion, they argued, it could not infringe upon those rights. Some, like Alexander Hamilton, even worried that listing certain rights might imply that any rights not listed were not protected. However, these arguments failed to persuade a large portion of the public, who feared that a powerful new government would inevitably seek to expand its authority at the expense of individual liberty. The intense opposition from a group known as the Anti-Federalists nearly derailed ratification. In several key states, approval of the Constitution was secured only with the promise that a series of amendments protecting individual rights would be added immediately. This promise was kept. In 1791, the first 10 amendments, known as the Bill of Rights, were officially ratified and became part of the Constitution. These amendments secured the fundamental freedoms that had been missing from the original text. The original Constitution thus proved to be a starting point, a framework that was durable yet flexible enough to be improved. The amendment process, outlined in Article 5, provided the mechanism for we the people to continue perfecting their union, ensuring that the promise of liberty would be expanded and secured for generations to come. Many historians view the original Constitution as a framework for government, while the amendments, especially the Bill of Rights and the post-American Civil War amendments, greatly expanded civil liberties and equal protection under the law. Together, they reveal a document designed to be perfected by generations, not frozen in time. The genius of the Constitution lies not only in its original architecture, but in our ongoing commitment to refine it. It remains a living blueprint, anchored in we the people.